I really enjoy the estate planning end of my practice. It feels good to help clients complete one of their most important responsibilities in life, which is taking care of their loved ones. And they feel good about getting their affairs in order too. I've had a lot of success with helping clients understand that estate planning should not be a one-and-done process. Instead, it is really an ongoing conversation we will have as time passes, circumstances and law change, and unexpected events occur. Many clients call or come in and tell me they want to prepare or update their will. I smile when they say that because a will is just one small piece of the larger estate planning puzzle. Let me walk you through what I consider to be the 4 core estate planning documents. 3 of the documents everyone should have. Then there's a 4th that I find a large percentage of clients should also have. First, a power of attorney for healthcare is an essential document for every adult, age 18 and older. Under a power of attorney for healthcare, you legally designate someone you trust to make medical decisions for you when you cannot do so for yourself. These decisions include what hospital to be in, medications to take, surgeries to have, and whether or not to continue life support. I recommend that a client also name 1 or more successor agents for this, but I strongly recommend against naming co-agents or multiple agents. When a power of attorney for healthcare comes into play, it is often during very emotional times, and the fact is everyone reacts differently to situations. In my opinion, naming more than one person to navigate and negotiate important and timely medical decisions for you at an extremely emotional and important time puts you at risk. You want to name a person that you believe will consider all important factors and can make tough decisions when called upon to do so. Secondly, everyone age 18 or older should have a power of attorney for property. This legal document appoints someone to act on your behalf when you cannot do so as it relates to managing your personal property and your financial accounts. This person may be called upon to make everyday decisions and actions, such as paying bills, collecting or forwarding mail, discontinuing unnecessary subscriptions and services, as well as filing and signing tax returns and dealing with government agencies. If you suffer an incapacity, things still go on and you need someone to step into your shoes and take care of the day-to-day things that require attention, whether expected or not. Again, for the power of attorney for property, I recommend naming 1 individual to act on your behalf. Naming 2 or more agents creates unnecessary delays and may lead to confusion or inaction. I do advise my clients to always name 1 or more successors. Of course, each spouse can name different individuals. The 3rd basic estate planning document is the will. Having an executed will in place is critical for every adult with assets that do not name beneficiaries, because a will names an executor for third-party asset companies to deal with after you die. Keep in mind that the powers of attorney are only valid and in force while you are alive. Powers of attorney become invalid the moment you pass away. A will is also important for couples with minor children because they can name a guardian to care for their minor children until they reach age 18. The guardian would become legally responsible for your child and will be the person to whom schools, medical professionals, and law enforcement will look to as the minor child navigates life situations. Many clients name a married couple as their child's guardian. This certainly provides for more stability for the child, but it is worth noting that in these situations, should the named couple become divorced, your child could become a point of contention. For guardianship, I also recommend naming 1 or more successors. One situation I often address is whether the grandparents should be named as guardians. It often depends on their ages, but I ask clients to keep in mind how demanding parenting can be, and then reconsider whether this role is suitable for these grandparents. Under a will, you can leave assets to your beneficiaries directly or in trust. Directly simply means the full amount is handed off as, here you go, take it. Leaving assets in a testamentary trust means that the trust springs into existence only after you die, where you name a third party, either an individual or a corporate entity, to watch over and distribute any inheritance for the beneficiary. until a specified time, age, or throughout the beneficiary's lifetime. An example here would be if any beneficiary is under the age of 30 when you die, the trustee you name will invest and distribute the assets for the beneficiary until he or she turns 30. Prior to age 30, distributions could be made for education, healthcare, and other needs specified in the testamentary trust. The fourth estate planning document that I want to discuss is a living trust. A living or revocable trust is an instrument that you create while you're alive, as opposed to a testamentary trust, which is created under a will for the time after you die. A trust is a legal agreement between the creator of the trust and the named trustee who administers the trust, pursuant to the agreement's terms. Generally, the settlor, who is the creator, and the trustee are the same person. The trust terms are binding upon the settlor, the trustee, and all future beneficiaries that are named under the trust. Often, the settlor retains the right to amend or revoke the trust at any time while living. Trusts serve as very beneficial documents to have both during a person's lifetime and then at death, whereas a will is triggered only upon death. Simply put, a trust is a legal entity that can hold your assets for you, both during your lifetime and then can distribute your assets according to your wishes after you die. When structured properly, a living or revocable trust can put the decisions in the hands of someone you trust rather than with the courts, can also avoid probate, and in some cases, save money on taxes. A living trust realizes its potential only when it is funded with assets. For example, when the title of the deed to your home is transferred to your trust then owns the home, and the trustee can execute transactions concerning the home, both during your lifetime and then after death. Of course, the initial trustee is often you, the settlor. If the settlor suffers an incapacity, the successor trustee can step in to deal with the property as needed. Any assets owned by the trust at the date of death would not need to be probated in order to transfer those assets to your beneficiaries. Once the trustee assures that all taxes and other administration issues are resolved, the trust assets can be distributed without the need to go to court. When or if a client should implement a living trust depends on the number of factors. First, what type of assets the client owns is important. Many assets can be transferred using paid-on death or transferred-on-death instruments, or beneficiary designations. Whether one or more of these non-trust techniques is advisable often depends on who the beneficiaries are. If it is not appropriate to leave assets directly to the beneficiary, then a trust is the better option. For example, special needs beneficiaries should never inherit directly, because that could cause them to lose their government benefits. In addition, financially immature or irresponsible beneficiaries should also not inherit directly. Trusts provide much better solutions in these situations. Clients may also have estate tax reasons for using trusts that cannot be satisfied with non-trust solutions. In Illinois, for example, an individual can leave up to $4 million to beneficiaries other than a spouse and/or charity, but over that amount, the state subjects the excess amount to an estate tax. If a married couple exceeds that amount, but there are reasons not to put assets in one spouse's name, such as a second marriage or a lawsuit against that spouse, then one spouse can leave assets in a testamentary trust for the other spouse in such a way to double their estate tax exemption amount to $8 million. This occurs, however, only if the transferring spouse dies first. Now you know about the 4 core estate planning documents and the legal purposes and the benefits of each. If you don't have one or more of these 4 documents already, I encourage you to reach out and put those in place right away. If you have an estate plan, but you haven't updated it in the last 3 years, it probably needs to be updated. Your circumstances may be different now, and the laws often change as well. My colleagues and I are here to help whenever you are ready.